I'd like to call the Tuesday, November 25th, 2025 right-of-way subcommittee meeting open. The first order of business is the approval of the minutes for the August 26th, 2025 minutes for our meeting. Is there a motion to approve those?
I move to approve minutes.
And as the only other member here, I will second that. All in favor? Aye. So the minutes are approved. Next, we have the staff report.
There is no staff report specifically tonight, Madam Chair, but I would like to make note of the Spring Ave extension matter that the subcommittee is handling. The next meeting for that is scheduled for January 6th, 2026, at the same location in Westerly, which would be the Senior Center. More information will be placed on our webpage and notify all interested parties.
Thank you very much. Item 3 is the Buttonwoods right-of-way, which is CRMC file 2019-03-119. With that, I'd like to turn it over to Mr. DeSisto.
Thank you. Would Mr. Langseth mind coming up along with Mr. DeVideo? The matter, and this is the petition of Richard Langseth, docket number 2019-03-119. The purpose of tonight's meeting is to accept a report from legal counsel on the status of the matter to date. The reason for that is, and I'd like to thank on behalf of the subcommittee, both Mr. Langseth and Mr. DeVideo, for the amount of work that they've put into this right-of-way and the amount of documentation that they've supplied both to the subcommittee and to myself and Mr. Hartman on this as to whether or not this is a Buttonwoods Avenue and Comstock or public rights of way to the tidal waters of the state of Rhode Island. Excellent job of research done by both. I want to thank them for their help on this. You have a copy of the report that we submitted. Mr. Langseth and Mr. DeVideo also have copies of the report. Basically, what you're looking at here is a dedicated right-of-way, Buttonwoods Avenue. And there are two elements that are required to make a street a public right-of-way. That is dedication, which clearly happened here. There's plats going way back, but the key one is the 1882 plat. So you have a dedication. The question is whether or not there's an acceptance. And all of the things that we received, there was no, to me at least, true official act by the town or city of Warwick accepting Buttonwoods. And in fact, and this is something that's relevant in some of the other rights of way that we have, which I'll get to in a second. In 1925, the General Assembly incorporated the Buttonwoods Fire District. And in Section 4, they conferred upon Buttonwoods Fire District the ability to maintain and repair and rebuild roads in this particular neighborhood. This has been a recurring issue for rights of way matters here in the state of Rhode Island. There was a time in the late 19th century through the first part of the 20th century where the General Assembly would incorporate these fire districts as corporations, but confer upon them certain functions that can be deemed governmental in nature. In this instance here for Buttonwoods, that function, maintaining the roads, was conferred upon the Buttonwoods Fire District. That to me means that those roads are private in nature and are not true public roads. So to me, there's the the dedication, but not the acceptance. So in the first instance, Buttonwoods is not a public right of way to the shore. However, as with some other matters you have, notably Spring Avenue Extension, there's two ways to accept a road under Rhode Island law. The first one is an official act by the municipality. Which is not present here. The second is by public user. That means that if the public has used Buttonwoods to access the tidal waters of the state of Rhode Island, then it can be designated as a right of way to the shore. The record is devoid on that issue, and that's why I recommend that the board, this subcommittee, not send this matter up to the full council, but instead schedule a public hearing in the city of Warwick on that one discrete issue as to whether or not there has been public use of this right of way, this private way. And if that's the case, then the council will have to make that factual determination. One final point that was raised by Mr. Langseth, and that is the whether or not, because of the state actions that took place here, that this is Buttonwoods Avenue qualifies under the state highway exception to the acceptance doctrine. And it did not appear to me that based upon the facts of this case, that applies here. And again, that was a legal determination on my part, although I think it was a good argument on the part of Mr. Langseth. So that is the status of the matter. I'd be happy to answer any questions you might have on this very interesting and unique area of which I know you're familiar with. Unique area of the state of Rhode Island.
Thank you. Should we just move ahead and schedule that meeting? Or I know that there are people here that would like to speak tonight. Should we hear from Mr. Langseth and Mr. DeVideo, or?
Well, before you make it, this is only a recommendation on my part. And I'm not going to say that I lead a horse to water, but can't make them drink. But that's my recommendation. I think it's appropriate to hear from the proponent, Mr. Langseth, and Mr. DeVideo on behalf of the Buttonwoods group before proceeding to any decisions that you might make.
Okay, thank you. All right, Mr. Langseth, would you like to state your name and be sworn in?
Richard Langseth, Budwong Farm Road, Warwick, of the petitioner pro se.
I'm not,
myself.
excuse me, and I'm sorry to interrupt you, Mr. Langseth. I'm not asking that Mr. Langseth be sworn in, because he's not going to be giving factual testimony. Rather, he's going to be making arguments. There might be some facts mixed in with that, but I don't think it's appropriate at this time to ask him to swear him in. I think he's really making arguments. It could be some factual, but he should be treated as such. Mr. DeVideo will not be sworn in. I'm sorry.
So that raises a question. Will this ever get to the point of cross-examination?
Not as to the legal determinations.
Okay. The weighing of the facts?
That would be coming at a later stage.
Okay. Thank you. Richard Langseth, pro se. At the onset of the subcommittee's review of my Buttonwoods right-of-way petition, the Buttonwoods Beach Association, the BBA, appeared before you and presented the Buttonwoods Fire District Charter into evidence. The date was March 26, 2019. The BBA's president, Peter Dorsey, commented that the BBA recognizes that the Buttonwoods Fire District has been delegated the power by the General Assembly to collect taxes and maintain the highways of Buttonwoods. It's very important. These are taxes. These are not fees assessed against the owners. These are taxes, which is puts the Buttonwoods Fire District in a whole different category than some private corporation. See Wood v. Quimby, Rhode Island, 1898, the Apponaug Fire District case, where the court found that the Apponaug Fire District's taxes were for public purposes only. The court followed Colby, the fire engine company in East Greenwich, Rhode Island, 1878, finding that the Apponaug Fire District was a public corporation, a quasi-municipality, not a private corporation, but a quasi-municipality. A quasi-municipality stands as any other municipality. So the Buttonwoods Fire District can accept the roads, which it did. So I agree with you, the city of Warwick did not accept the roads, but the fire district clearly did. The Buttonwoods Fire District was in 1925 when it was enacted into law and still is 100 years later in the same situation. It is a public entity holding public property through its lease with the BBA. The lease was created in order to facilitate FEMA funding. The federal government did not want to fund emergency relief to the Buttonwoods without the fire district controlling the roads. And this was done through a lease with the BBA. The fire district is responsible as an owner of the streets, an owner pro tanto. This is McKee versus McCarty, Rhode Island, 1900, citing Gilligan versus Alderman of Providence, Rhode Island, 1875. The fire district's highways and parks are public, not private, citing Wood v. Quimby. In 1984, the BBA petitioned the General Assembly for it to legislate the BBA's 1882 plat of its streets and parks into public acceptance of the BBA's dedication to the public. We all agree the BBA dedicated the streets to the public, and Mr. DeSisto was presenting an idea that it has not been accepted by the city of Warwick, so therefore it's not accepted. However, what I'm saying is it was accepted by the Buttonwoods Fire District, which stands the same as the city of Warwick. The annexation of taxable properties and public streets and parks by the people themselves via the General Assembly, citing Cole versus Fire Engine Company. The BBA's surveying and platting competence was shown in reservation. This is, we don't need to talk about this because we all agree that the plat was dedicated by the BBA. The BBA's 1882 replat dedicates Buttonwoods Avenue to Buttonwoods Point to the public. I think we all agree that happened. So if in fact the streets were accepted by the public in one way or another, they do go to the tidal feet water area, which is very important. If it doesn't go to the tidal water area, then we don't have anything to talk about. But the staff report shows it going to the tidal water area. And then I talk about a reserved street, Hemlock Avenue being reserved, that shows that the BBA knew how to do a plat. We all agree. The BBA's 1882 replat dedicates Buttonwoods Avenue to Buttonwoods Point to the public and dedicates a park abutting the street at Buttonwoods Point to the public. The park was not mentioned in the staff report, but it does exist, and then I presented it in certified evidence from the city clerk. When the General Assembly enacts its acceptance of both in 1984, the BBA's 1882 incipient dedication demerges into a full public acceptance by legislative enactment. This is Knowles v. Knowles, 1903. You stated that Knowles v. Knowles required the state to own the property. I didn't read that in the case. I think Knowles v. Knowles says that the General Assembly can accept a street as a public. That's my reading of Knowles v. Knowles. Because of this acceptance as in the form of a legislative enactment, the subcommittee can notice the results of the enactment, but does not have the power to adjudicate it. Now what we're saying here is separation of powers. The administrative agency can read the legislation, but it can't adjudicate or interpret it other than the plain reading of it. That's the City of Pawtucket versus Sunderland, 1995. Following White v. City of Cincinnati, U.S. 1832, this enactment stands as constitutional. The question is the dedication and the acceptance a taking? The U.S. Supreme Court ruled in 1832 that when a buyer dedicates a street to the public, the use of the street by the public is constitutional. That's White v. City of Cincinnati. The enactment by the General Assembly more than meets the substantial evidence requirement for the CRMC Enabling Act, Sater versus CRMC 1988. The 1984 annexation stands as a fact to be noticed, but not subjected to administrative challenges or other adjudication by the subcommittee. This is Pawtucket versus Sunderland. The BBA's Peter Dorsey's recognition of that legislative act, placing the taxation of the Buttonwoods domain for highway maintenance in the hands of the Buttonwoods Fire District, quiets any controversy about this matter. The fire district, a public entity, maintains the street for the public as enacted by the General Assembly, the people. This is Cole versus Fire Engine Company in East Greenwich. Now what happened in Cole is that what recently became the East Greenwich Fire District, but previously was a fire company. There was an adjudication against the fire company, and they were supposed to pay damages, and they refused. And then the Coles came in and said, "Hey, wait a minute! This fire company can raise taxes. Okay, it doesn't have any physical assets, but it can raise taxes." And the Supreme Court said, "Yes, that's true. That this company is a public entity. It can raise taxes." And from there, we have Woodbury Quimby, where the Supreme Court said, yes, a fire district is a public entity and all its holdings are public and all its activities are public. You can't call it private because it is public. Now that's the Rhode Island Supreme Court in 1903. Now I'm requesting a public hearing, but you all agree that there's going to be a public hearing. The question is, at the public hearing, are we just getting public comment, or in the Spring Avenue public hearing process, we have the attorneys arguing against each other in public. And what I'm reading from you is that this public hearing will just be members of the public, and I can call myself a member of the public and say I walked down the street. But is it going to go beyond that? Is it going to be attorneys speak to, or is it just going to be the people saying that they did or they didn't go down the street?
If we want to have a timely hearing, we'll limit the lawyers. You can speak, Mr. Langseth, at the meeting. You can even raise some of these arguments if you want. But to me, the purpose of this meeting is for the public to get up and say what type of use they have for this.
Okay, so I could be a member of the public.
Absolutely. And as the petitioner too, by the way.
Okay.
Because it's your petition.
Okay.
But as a member of the public, you can testify to what you've done.
Okay.
That's factual.
And then that's subject to cross.
Not so sure that the case there in Barrington, what's the name of it? Troiano. I'm not so sure the Troiano case applies to that.
Okay, so we have the public hearing, the public comes, members of the public are owners of the beach association. Now, wouldn't I ask if they're members of the beach association? Because if they're members of the beach association, they are possibly stopped from fighting the petition.
No, I don't think estoppel applies. I think somebody from the beach association get up and say, look, I haven't seen any members of the public going there. I think they have a right to say that.
Okay. Regarding BBA objections, I assume that there were going to be BBA objections. Firstly, estoppel. The BBA replatted the streets of Buttonwoods in 1882 and filed a plat map with the town clerk following the predecessor in interest, the trustees who were required to secure their mortgage in 1872 by platting and opening the streets, and on and on. We all agree that this dedication was presented properly by the Beach Association. The Beach Association dedicated the roads to the public. I think I heard you say that. So, okay. The BBA's replat was a manifest, obvious, incipient dedication. Yeah, we all agree. So, in that mind, the BBA, having dedicated the streets to the public, can't come in now and argue against the dedication of the streets to the public. I guess they could argue against public use, but they certainly can't say we didn't dedicate the streets to the public. I think we all agree to that.
Well, I'm not agreeing to anything, but please make your arguments. You're preserving them for the record.
All right. Separation of powers. The BBA has brought a reinterpretation of the Buttonwoods Fire District enabling acts of the General Assembly before the subcommittee. The BBA made the claim that because the highways at Buttonwoods are not highways of the city of Warwick, they must be private. The subcommittee cannot adjudicate this under separation of powers. That's City of Pawtucket versus Sunderland. You can't adjudicate what the General Assembly writes down and is in clear language. Separation of powers. We can go to Mayberry versus Madison if we want. I mean, but that
Marbury.
The BBA is attempting to put words in the mouth of the General Assembly and have the subcommittee agree to the same. The obvious answer is that highways of Buttonwoods are not highways of the city of Warwick because they are highways of the fire district. And as we said before, the fire district can only do public things. It can only hold public property. It can only spend taxes for public use. So to say the fire district is a private entity is objected to by me and will seriously be challenged. Okay. Parole evidence. The BBA's replat of 1882 is whole, a complete document. If unambiguous, it stands alone without parole evidence. What I'm saying here is the Beach Association should not be coming into this body and saying the city of Warwick says that this is private. No. Perhaps they could say the public can't go here because it's private, but they can't say the city of Warwick says this is private, so therefore it's private. That's the dedication is complete. It's an unambiguous plat map. You can't apply parole evidence against that. So all that evidence about the city of Warwick is thrown out in my mind. See if there's anything else here. Yeah, I definitely question the fact that it's said that the fire district's private and the roads are private. I just can't find anything in the law that goes to that. And I submit that when the Beach Association comes in and says we've dedicated the roads to the public, however, they're private roads. That doesn't work. I mean, if you dedicate the roads to the public, for your point of view, they're public. Whether that's been accepted or not is something else. However, you can't say they're private now because you said they were public. That's an estoppel.
Thank you.
As best I can explain.
Thank you.
Thank you very much, Mr.
Oh, is
Langsdorff.
there anything else? Ohio State Highway exception, I agree. Thank you.
Yes, good evening, members of the subcommittee. So just to answer your question about Troiano, as you know, we have that case up on appeal. That was a contested case. Yeah, it's up at the Supreme Court. They have a Superior Court. They haven't yet rendered a decision. That's correct. Yes, it's been briefed.
Is that relevant to this?
It is because I didn't interrupt you, so I appreciate if you let me speak. So with respect, because Attorney DeSisto mentioned Troiano, and in that case, the applicant had the right to cross-examine witnesses who were presenting evidence. That was a contested case. Here, this proceeding we're on right now is not a contested case, not yet. It won't be a contested case until the council is actually going to rule if this is only a recommendation as to what you're doing. There's nothing, no final agency action happening here. Right? And you make it, there's a recommendation to the subcommittee. Subcommittee makes a recommendation, for example, to have a public hearing and warrant. Then they make a recommendation to the full council as to, is this a public right of way or not? That, in my estimation, becomes a contested case because a final agency action will result from that. At that time, of course, there can be cross-examination of witnesses. I just wanted to assist on that because I know you mentioned that the Troiano case and where there's a difference here, which goes to maybe the procedural process here. So at our, not just the last one, but particularly the last meeting, it was made very clear that staff would prepare a report. That report would be distributed to the members of the subcommittee and the parties would have an opportunity to provide a written response. And I've only received this report literally this evening. So in order for me to, or for that matter, the petitioner to present meaningful rebuttal or argument or to this report, we would need time. And just at first blush, I know that there's this finding by council that a dedication occurred because a plat map was recorded. And I think it's referring to Kilmartin. But that's not the end of the story. Okay? Because an intent to dedicate, you need to have demonstrated that such an intention was actually what the owner wanted. Simply recording a plat map for what they intended to be a private neighborhood so they could sell lots according to these private rights of way does not mean that's a dedication. And in fact, Rhode Island law presumes against dedication without clear intent. Intent is not simply recording a plat map. That's too simplified in Kilmartin. In fact, in Kilmartin, what they actually said was, hey, these guys knew how to dedicate public rights of way because they label them as public rights of way. These plat maps do not label them as public rights of way. So to make that so simplistic or formalistic or formulaic, that the recording the map equals dedication is, I disagree with legally. Okay. And this has been and again in Volz v. Marina Parks, there's a presumption against dedication, and clear evidence is required to overcome that presumption. Now, as I've argued in my papers, there was a clear intention of the original subdividers here to create a private resort community. And that's what you can use. You can use this other evidence, whole evidence in the record. That was their intent. They had a hotel there to draw in people so that they could stay at the hotel and experience, hey, do I want to buy a lot in this neighborhood which has private facilities? So I want to be able to present argument against that position that council has taken. Plat recordation equals dedication. And it's not that simple. And again, because it was promised to us, the process was explained to us, report, dissemination, opportunity to respond. And I clearly have not had the opportunity to digest this in a meaningful way to respond as promised, that we'd be able to provide written responses. Not just for you, but for the subcommittee. So I respectfully request that which was promised, and I think intuitively makes sense to provide. And I don't want to go too deep. I only want to address this, the findings that you've made insofar as dedication. That's really the critical issue that I'll be arguing.
You know, I beg your pardon. I beg both of your pardons. I do recall that. I forgot.
I reviewed the video today.
Unfortunately, you're correct. And I
make sure I was not making up.
No, I beg your pardon. I do think it's appropriate to allow both Mr. Langseth and Mr. DeVideo to file responses. I beg your pardon.
Thank you.
Can I suggest we move forward with the public hearing? The public hearing, as I understand it, is for public comment to determine whether the public use the roads, and it has nothing to do with the dedication questions that he brought up. I think we should be able to move forward with the public hearing while this other process goes on.
No, because first you have to have dedication.
We have.
Well, no, and I disagree that dedication, that's why I want to present written argument, because I disagree that the first step, dedication, occurred. Then if I do dedication, then we go to acceptance, not by the municipality accepting it, but by public use. So it's premature to have public use hearings when I should have an opportunity to refute dedication.
If I may, Mr. Langseth.
One other comment.
Okay.
The BBA petitioned the state to use the dedication to create the fire district. At that point in 1984, the BBA had a clear intent to use this dedication as an incipient dedication because it told the General Assembly of that, and you cannot lie to the General Assembly.
Mr. Langseth, I'm going to say this. It's actually because of the arguments that you've raised in your portion here. I don't think it's a good idea to schedule the hearing at this time because, if the subcommittee accepts and agrees with your contentions, that's going to shift the public hearing in what the scope of that public hearing will be. So I think it's prudent at this time. Please agree as to what time limit you need for you both to file your rebuttals at the same time. But depending on what comes out from that, if your position is adopted by the subcommittee, that's going to change the very nature of the public hearing. How much time do you need?
Just for clarity, because I know that sometimes these things meander, but just for clarity and for the record, there's going to be an opportunity for the petitioner and respondent to file a response to the report prepared by legal staff. It'll be filed on the same day, right?
Yes.
No sir replies, no replies, nothing like that, right? Just a straight up response, like they do in the land court here in Rhode Island in front of Judge Lanphier. Then that also has to be. Does that have to be the 5 copies down to Tracy? Can we just email it to make it a little more simpler?
Yes.
And I'm not sure 4 p.m. or 11:59 p.m. that day. Just want clarity on that procedure.
Can I answer that?
Yeah, I think Jeff ought to answer that.
3:59. 4 o'clock, of course, is when we close. So I would like to have it before we close on any particular day. And it's the 25th of November. Can we say that the next 35 to 45 days that maybe pick January 15th?
Well, you got holidays and stuff like that. So, that's fine with me, January 15th, if that's appropriate for you folks.
The subcommittee has other matters that it's dealing with. So, and they'll have a hearing on another matter early in January anyway. So if January 15th gives you both parties enough time. So what day of the week is that?
2016 is a Thursday.
So then why don't
make it Friday?
we are
January 16th.
we are January 16th by prior to 4 o'clock. Thank you.
Good.
And by email.
Email is fine.
So I do have one question. He presents, do I get a chance to rebut? I mean, it sounded
No.
like this is going to be it. I mean, I would think that we should have, like in Superior Court, 5 days to rebut.
Well, and I'm going to tell you this, Mr. Langseth, we have a land court in Superior Court now, and the practice that's been adopted there is that briefs are filed simultaneously as opposed to one brief comes in, then there's a reply, and then there's a reply after that.
Yeah.
So in other words, what we're looking at here is, you all have, I mean, there's been a lot of material on this thing. Now, we've come up with a what we consider to be a distillation and a recommendation as to the law, which you dispute and which Mr. DeVideo disputes, which tells me that we probably did the job we were supposed to do. So this is an opportunity, both the arguments tonight were excellent. Going to give you all an opportunity to raise the points that you've raised. And then once that comes in, we're not going to respond to it. The subcommittee can take it up and make the decision there.
And there can be discussion at that meeting.
Absolutely.
Okay.
Very good. Thank you all.
Hey, you know what? Thank you two very much for all your help on this thing. I think you both did a great job on this, not only on the research, but also raising excellent points of law. The arguments were fantastic. Thank you very much.
Thank you.
Do we shouldn't do that in a motion.
Do it in the form of a motion to have the parties brief it out to January 16th.
Okay, so the subcommittee, could someone make a motion to provide, to continue this, to provide an opportunity for the parties to address the findings and file responses by the deadline of January 16th at 3:59 PM. And this can be done electronically. And I'll second that. So the motion's approved. I think that's it for the subcommittee meeting.
Motion adjourned.
Motion to adjourn.
Aye.
Meeting adjourned.